We're here today with Chris Collins, head of our Labor and Employment Division, talking about employment law. Chris, how did you get into this area of law?
Well, as a former prosecutor, I developed a love for helping people who had been victimized, and that carried right over into my private practice. I'm very comfortable being on the plaintiff side, and so when I see somebody that needs help, I want to step right in and help them. And my first job out of prosecuting was for a local firm here in Roanoke. Worked for a partner who specialized in employment law, certainly one of the leading attorneys in this area, and learned a tremendous amount as a result of that.
And so what kind of employment cases do you take? Are there different categories? Do you represent businesses or just individuals? Can you tell us a little bit about that?
Yeah, we represent businesses and individuals, plaintiffs and defendants. Obviously, I'm more comfortable having been on the plaintiff side as a former prosecutor, and that's a position that requires somebody who's fairly aggressive, and I definitely check that box. But yeah, typically those plaintiffs' cases fall into one of three categories. First of all, you've got Title VII, which is discrimination cases based on some category that is protected, such as race, gender, age, etc. The second category would be FMLA, Family Medical and Leave Act. Those are cases in which somebody has asked for time off from their work, either to deal with a serious medical condition that they have or some family member of theirs. And that's been modified somewhat in this COVID era that we're living in now. And then the third category are cases dealing with employee benefits, and those typically fall under ERISA. ERISA cases tend to be the most complex types of cases, sometimes requiring years to litigate fully.
And have you ever done an ERISA case?
Yes, I actually represented a plaintiff in Amherst a few years back. This was a lady whose employer had failed to pay her health benefits, and as a result, her health insurance was cut off. And unfortunately, it was right before she had to seek some very expensive cancer treatment. And that cancer treatment went on for a period of months and even years. And fortunately, we were able to get her a substantial judgment, several $100,000.
So if somebody's watching this video and they think that they're about to get fired or they're in a bad situation at work, what should they do? Should they quit and then call you? What are the steps that they need to take?
Well, rule number one is don't quit. Right? The first thing you want to do is call me, because I assure you, in the vast majority of cases, your employer wants you gone more than you want to be gone. And if you quit, you're just giving them what they want. So give me a call. Let me walk you through what your rights are and what the dominoes are going to fall based on what decisions that you take. It doesn't cost anything to speak to me. In fact, in most cases, the beauty of employment cases are that I can either take your case on a pure contingency, which means you don't pay us anything unless we recover, and you only give us a portion of what we do recover for you. But in some cases, we can actually make your employer pay our attorney fees, and that's the beauty of this area of the law.
And are you afraid to take on a large company if necessary?
Absolutely not. A good case is a good case, and if someone has been wronged by their employer, we're going to seek justice on their behalf.
All right. Thank you, Chris.
Thank you.